Justice Thomas, anything further? Justice Alito?
Would you explain why the anti-poaching laws that Justice Kagan was talked about are not, in your view, an appropriate analog?
Absolutely. Those poaching laws, as the Sigmund article and other sources and the text of the laws themselves exemplify, show the opposite of the tradition Hawaii is trying to show. They show that for property closed to the public, the people have taken steps to enclose for improvements to protect the fields from being trampled by hunters. For that special category, there were laws that said you have to get affirmative consent, sort of like Justice Barrett's questions about do you need affirmative consent to go into dwellings. The rule for other property open to the public, open fields, was the exact opposite. There was a conscious decision at the founding, because hunting was an incredibly important issue, that if you did not enclose your lands, it was an open invitation to carry, and that's consistent with the tradition at the founding of public carry that the NRA amicus, for instance, details. The idea that Hawaii's law is a relevant analog would just take away the level of generality to just justify the opposite of the tradition. It would have been profoundly disturbing to the founding generation to hear that in order to travel at inns or taverns or anywhere else, people commonly carried arms, that they had to get the affirmative consent of each sort of tavern and hope that they weren't trespassing if they were traveling and their carriage had to stop somewhere.
In order to determine whether an analog is adequate for Bruin purposes, is it possible to disregard how do you choose the level of generality? What is the principle that tells you what is the relevant level of generality?
I think here the relevant level of generality does revert to some the property law concepts. If you're talking about property open to the public, the relevant comparator is property open to the public, because there is a relevant common law tradition of certain permissions that go there. And when the state is essentially presumptively banning or switching the tradition, I think that is an issue. So I think that's relevant. And to disregard the clear text of these statutes, which are focused both on property, that distinction between property closed to the public and open to the public, and the specific question of hunting, would allow you to abstract out everything. It's the same thing the court rejected in Bruin, that just because some places, for instance, might be sensitive places, every place could be a sensitive place on the same reasoning at too high of a level of generality.
What do you think is the purpose of the Second Amendment right?
The purpose of the Second Amendment right is to allow citizens to bear arms for self-defense and other lawful purposes.
And other lawful purposes?
Yes.
Not just self-defense. Did Heller say that?
I don't think Heller excludes it, and I don't think the court has to decide is it self-defense and other things, but it would be, again, sort of strange to think that you cannot use arms for any other purposes when the founding generation considered arms important not just for self-defense, but for instance for making sure that people were proficient in arms to be able to defend the country. So I don't think that there is sort of necessary, but I don't think the case presents the question.
Do you think it's possible to ignore the purpose of the Second Amendment in determining the level of generality that's appropriate?
I think that it depends on the case. For this particular case, I don't think the court has to resolve it, because the point here is Hawaii is saying its law is supposed to protect private property rights, and it's essentially trying to negate people's right to publicly carry everywhere.
Justice